Hi, welcome to the second part of our video lecture in Module 4-E. In the previous video, we have established the existence of quasi-judicial powers within the framework of the DAR, within the framework of RA 6657. We have identified the specific officers and offices within the framework of the DAR which exercise the quasi-judicial functions as vested by law, as vested by RA 6657. We also determined the three uh, groups of cases that fall within the purview of agrarian dispute. We said that an agrarian dispute may be first, a tenurial arrangement controversy. Second, a just compensation controversy. Or third, criminal violation under RA 6657. All right. Uh, in the first video, we have already discussed the procedure, the rules with regard to the tenurial arrangement controversies. In this video, we shall discuss the just compensation controversy, rules and procedure, and then the uh, criminal actions under RA 6657. All right. So here, let's start with the rules and procedure for disputes involving just compensation. Now, it's different. The procedure is quite different from tenurial arrangement controversy. Firstly, because in a just compensation controversy or dispute, as I've pointed out in the previous video, uh, it does not require prior mediation or conciliation. Right? In fact, uh, a just compensation dispute be uh, uh, will be cognizable by the offices exercising quasi judicial bodies uh, under within the framework of DAR, uh, even without a prior mediation and conciliation. Right? If you can remember the procedure for land acquisition, there is that point where the landowner rejects the initial valuation, initial offer by the DAR. All right, and then when that happens, when the landowner rejects that initial valuation, then the proceedings will have to move to the administrative determination of just compensation, right? And if you could recall, the administrative determination of just compensation will be done either by the provincial adjudicator or the regional adjudicator or even by the DARAB itself, right? And we have said in that module that uh, the existence of the provincial adjudicator, regional adjudicator, and the DARAB for purposes of administrative determination of just compensation is not some sort of a hierarchy, right? For purposes of appeal, no. It, in fact, the hierarchy there or their existence there is just delineated by the amount, all right, that they are allowed, or the amount of initial valuation, okay, that they are allowed uh, to administratively determine. Okay, and so when the amount is like this for Parad, when amount is like this for Rarad, amount is like this for Darab, they will have the jurisdiction to uh, to determine, right, just compensation administratively, as we have already discussed and settled. The fact that the law gives these administrative bodies the power to determine just compensation, all right, does not make RA 6657 unconstitutional. All right, um, because RA 6657, although it grants the administrative agencies, the PARAD, the RARAD, and the DARAB, the power to determine just compensation, okay, that grant is not exclusive, all right, to administrative agencies. And consequently, that grant does not deprive the courts of their judicial prerogative to determine just compensation. According to the court, in the case of Association of Small Landowners versus Secretary of DAR, no, uh, the fact that these Parad, Rarad, and Darab are given that power to determine just compensation does not mean that the judicial prerogative of the courts are already impaired. In fact, the determination of the Parad, of the Rarad, and the Darab is just preliminary in nature. And it is not binding to the court, right? It's not binding to the court, and therefore the courts are not deprived of that judicial prerogative. Okay? Even though these administrative agencies have this power to determine preliminarily just compensation. We also recall that insofar as these administrative agencies are concerned, DARA, PARA, DRARAD, uh, the the factors under RA 6657 must be at all times be followed. All right, the factors under RA 6657 insofar as these administrative bodies are concerned must be followed. All right, they do not enjoy the same kind of judicial prerogative that is vested on the courts, and therefore they being creatures of the law, creations of the law, must adhere to the law, must adhere to the factors laid down by the law, right? And so for these administrative agencies, they are given that power. In fact, this is a quasi judicial power to preliminarily determine just compensation. Okay? But after that, after the preliminary determination of just compensation in a summary hearing by these administrative bodies, the proceeding will now move to the courts. It will now move to the courts. But note, it does not go to the courts in an appellate manner. It does not go to the court by way of an appeal. Okay? Because the courts, no, specifically the Regional Trial Court or the RTC, sitting as a Special Agrarian Court or an SAC, okay, will have original jurisdiction, not appellate. Okay, will have original jurisdiction and exclusive jurisdiction over the case. Okay, it's original as provided for by RA 6657. It's not appellate and it's not exclusive. That means the case that is filed with the RTC is not an appeal. Okay, it's there filed in the first instance. Okay, even though there was already a prior determination by the Parad, Rarad, or Darab as the case may be, okay, the case filed with the RTC sitting as an SAC is an original case. It's not an appeal from the Rarad, Parad, or Darab as the case may be. And therefore, okay, being not an appeal, it is not governed by the reglementary period provided for under DARAB rules, no, the 15-day period. Because it's not an appeal, it's an original action, and original actions and within in the rules of court, original actions have no reglementary period in the rules of court, except of course for prescription in substantive law. But here, for original actions uh, that would want to question the preliminary determination of the administrative agencies, PARAD, RARAD, or DARAP, the case is not appellate but original. Okay, and it may therefore be filed even outside the 15-day period under the DARAP rules. All right, and because it's original, all right, the decision of the court in this case, in this uh, case questioning the preliminary determination by the administrative agencies, all right, the decision of the court is also promulgated in its original jurisdiction. Okay, because the case is original. Note, however, that even if the case, I mean the decision of the RTC sitting as an SAC was promulgated by virtue of its original jurisdiction, okay, we do not go to the Court of Appeals via ordinary mode of appeal. Okay, now I know you will learn this in your appellate jurisdiction. I mean, sorry, in your appellate uh, uh, law practice, in your that's a course, appellate law practice. But just for general knowledge lang, all right. Perhaps you will also learn this in your civil procedure. When it comes to appeals from the RTC, from the Regional Trial Court, there are uh, basically two modes. Okay, first, ordinary appeal, and second, a petition for review. Now, when do we resort to an ordinary appeal and when do we resort to a petition for review? Now, under Rule 41, okay, we resort to an ordinary appeal from the decision of the RTC if the decision of the RTC was promulgated in the exercise of the RTC's original jurisdiction. Okay, meaning the RTC decided on a case that was filed before it in the first instance. Okay, while we resort to a petition for review under Rule 42. Okay, if the decision appealed, okay, was promulgated by virtue of the RTC's appellate jurisdiction. In which case, the RTC decided on an appeal from the MTC, meaning it came from the MTC, it was appealed to the RTC, and the RTC decided on that appeal. Now, if you want to appeal from that decision of the RTC in its appellate jurisdiction, you go to the Court of Appeals, not via an ordinary mode of appeal, but via petition for review under Rule 42. Now, since we have an RTC which is sitting as an SAC deciding on a case that was originally filed before it, which mode of appeal do we adopt in going to the Court of Appeals? All right. The answer is neither. Not ordinary appeal under Rule 41. Also, not petition for review under Rule 42. All right? Because insofar as RTCs sitting as SACs are concerned, insofar as their decision and the appeal from their decision are concerned, okay, there is a third kind of appeal, no, from the RTC sitting as an SAC. Okay, the third kind is that it's an appeal via Rule 43. Okay, appeal to the Court of Appeals via Rule 43. Attorney, these are all different appeals, attorney. But same destination, attorney. Why distinguish? Okay, very important to distinguish, because under the rules of court, these three have different or varying requirements, procedural requirements. And so it's important that you understand and identify what kind of appeal, okay, what mode of appeal do you resort to, even if this just the same, even if it's the same, the same court of appeals, because the procedural requirements vary, and more often than not, the procedural requirements for the, the, the respective procedural requirements for these three appeals would be mandatory. All right, so very important to note that. Okay, now why do we say that when we appeal from the RTC's decision sitting as an SAC, we go to the Court of Appeals via Rule 43? Isn't Rule 43 a mode of appeal from decisions of quasi judicial bodies? And an RTC sitting as a special agrarian court, that's a judicial body that's there in the judicial branch of the government. Why do we resort to Rule 43? All right, this question actually was answered was answered by the case of Land Bank versus De Leon in 2002. In this case, the Supreme Court said that an appeal from the decision of the RTC sitting as an SAC will have to be to the Court of Appeals via petition for review under Rule 43. Okay, why is that? Firstly, the court admitted that an RTC sitting as an SAC is not one of those offices or tribunals enumerated under Rule 43. If you can try to see the enumeration under Rule 43, Section 1, you can not find there an RTC sitting as an SAC, right? You would not find that there, right? But then, even conceding that an RTC sitting as an SAC is not found there, the court established that the enumeration under Rule 43, Section 1, that's not exclusive. That's not meant for exclusivity, right? So that even if a tribunal, even if a court for that matter, is not enumerated under Rule 43, it does not automatically mean that Rule 43 cannot apply. Okay? More so because under Section 60 of RA 6657, the law prescribes that an appeal from the RTC sitting as an SAC must be by virtue or must be via petition for review. Okay? Now, Section 60 does not provide for the rule number. Does not say petition for review under Rule 42, does not say petition for review under Rule 43. Now, the Supreme Court stated here that certainly, no, certainly it's not Rule 42, right? Because Rule 42 pertains to appeals from decisions of the RTC promulgated in the exercise of their appellate jurisdiction, right? Here, the case that was filed with the RTC sitting as an SAC is not an appealed case. In fact, diba, it's an original case. All right? But again, even though it's an original case, because the law states that it should be via petition for review, then it's not an ordinary appeal. All right? And so the Supreme Court said that because Section 60 says petition for review, then it must be under Rule 43, because Rule 43 also is an appeal uh, via petition for review. And the Supreme Court said that anyway, there is no rule that disallows this procedure. There is no rule which states that an RTC decision cannot be appealed to the Court of Appeals via Rule 43. Again, the enumeration under Rule 43, that's not exclusive, right? And therefore, since there is no such barrier, legal hindrance, then according to the Supreme Court, uh, the appeal from the decision of an RTC sitting as an SAC should be brought to the Court of Appeals, not via Rule 41, not via Rule 42, but via Rule 43. Right? So now let's go to criminal actions. Okay, of course, from the Court of Appeals, it has to go to the Supreme Court, no? Supreme Court via Rule 45. Right? Now let's go to the criminal actions under RA 6657. Just in case there are criminal actions under RA 6657, what would be the rules? What would be the procedure that are applicable? And the procedure would be can be illustrated through this. Okay. Now this is under DOJ Circular Number 40-2010. Of course, because the prosecutor's office, the prosecutors are within the structure of the DOJ. No, the DOJ uh, uh, promulgated this circular to guide the prosecutors in case the cases will involve agrarian dispute. Okay? Now, it will have to start with the filing of a criminal complaint, a criminal case before the prosecutor. Okay? Perhaps you've already discussed uh, in your criminal procedure, no, that preliminary investigations, they are required in some cases depending on the penalty attached to the case. All right, but for purposes of our discussion, let's just discuss the procedure for criminal cases involving which require preliminary investigation. Now, because a case because this case, criminal case, requires preliminary investigation, you don't file it directly to court. You file it first with the prosecutor's office. Okay? And now, the prosecutor's office will have to afford the respondent the opportunity to be heard. Okay? And so, this criminal case will move forward by issuing a subpoena to the respondent indicated in the case. And the subpoena will also contain the criminal complaint, where the respondent will be given the chance within a fixed period of time to submit his or her counter affidavit, where he or she will be presenting his or her defense. Okay? Now, it is possible that the respondent will raise an agrarian dispute, for example. All right? The respondent will raise, for example, that this is not a case for qualified theft. This is a case of a dispute involving shares, dispute involving agricultural lessees, agricultural lessor. In which case, when the respondent raises this agrarian dispute, the prosecutor has the duty to refer the matter to the paro for determination, okay, of whether it is proper for trial or not proper for trial. No? Meanwhile, the case or the preliminary investigation will be held in abeyance. No, pause while the paro determines. No, the paro means Provincial Agrarian Reform Office. That's the provincial office of the DAR. All right. Uh, the prosecutor will have to hold the preliminary investigation in abeyance while waiting for the paro to determine whether it is proper for trial or not proper for trial. All right. But the paro has only 15 days from receipt of the referral to determine, okay, whether the propriety of the propriety for trial of the case. No? Now, as I've said, when the paro certifies that the case is not proper for trial, meaning the case should not yet be tried, okay, pending the determination, the final determination of the agrarian dispute, then the paro will certify that and the case will be dismissed. No? In order for the agrarian dispute to be resolved first before the criminal case will be filed. Or the paro will also say, oh, this case, although it involves agrarian dispute, this case may be tried, may be proper for trial. In fact, it is proper for trial, even though there's an existence of agrarian dispute. All right? In which case, the preliminary investigation will proceed. Note the determination of the paro, again, just like the determination of the DAR in a tenurial arrangement controversy, that's appealable. No, not final. It's appealable. And for purposes of this procedure, because it's only the prosecutor, no, and as the rule would show, if it is a prosecutor which refers the matter to the DAR, then the determination of the DAR, or the paro in this case, will be appealable to the RTC. Right? Now, if the paro certifies that the case is proper for trial, then the matter will proceed with the preliminary investigation. Okay? And in that preliminary investigation, the purpose is to find whether there is existence of probable cause or not. Because if after preliminary investigation, the investigating prosecutor concludes that there's no probable cause to support the filing of a case in court, of a criminal case in court, then the criminal complaint will be dismissed. All right? But if the prosecutor says or concludes that, oh, there is probable cause here, okay, there's probable cause here, and this matter involves agrarian dispute, then we file the case not with the regular courts, but with the RTC sitting as a special agrarian court. Okay? Because the RTC sitting as the special agrarian court will have jurisdiction over criminal actions under RA 6657. Okay? Or under criminal actions uh, under agrarian laws. All right? In which case, therefore, the criminal complaint will have to be filed with the RTC, all right, acting as a special agrarian court. And from there, it will be tried according to the normal procedure for criminal cases. All right? That actually ends our discussion for module 4-E. All right. After this one, as I've said, we have already officially closed our agrarian reform law part of the course, and so the next meeting, or the next week, perhaps on the 29th of October, we can have our midterm examinations. All right. Uh, and then after our midterm examinations, we will move to the second part uh, of our discussions of our course, which is on the other pieces of social legislation. Right. So God bless you in your midterm examinations, and see you for the rest of the course. Thank you.